Welcome back. This morning in our first interview, we are hosting Mr. Sharad Rao. He's the chairman of the Judges and Magistrates Vetting Board. Of course, the discussion is matters judiciary. So any questions, comments, suggestions that you may be having, 22422 is the SMS line, or you can get us on Twitter. The hashtag is Power Breakfast. For now, I hand you over to Mr. Mutegi Njau. Mr. Njau?
Thank you, Kirigo. Good morning, Mr. Rao.
Morning.
Good morning. You are coming here at a time when the judiciary is under problems. There is a crisis there, and your term is supposed to end at end of March. And I don't know whether you think you have achieved what you're supposed to.
I would say we have achieved not wholly, but to a great degree. And I think we were able to restore confidence in the judiciary. That is why
people may not believe that.
Well, I think about 85% of the public does. I can tell you where the problem lies. The problem lies in the fact that the weakness as far as our process is concerned, we were restricted to those who were in office on the 27th of August 2010. And
before the new constitution.
Then the new constitution came into effect.
Yes.
And what we were doing until we had a decision of the Supreme Court, we told us otherwise. What we were doing is to look at the conduct of a judge or a magistrate before his appointment, because some of those appointments were always with a question mark. You know, in the days when they used to appoint, whether the State House appointed or they were appointed on the recommendation of someone, they didn't actually go through the process that a judge or magistrate now goes through. So we used to look at his conduct before the date of appointment, up to the 27th of August 2010 and beyond. And the beyond was important because we were not only looking at his conduct, but we were also looking at his financial position. We were looking at what the Chief Justice now is telling us to conduct a forensic audit. That's what we were in effect doing up to about 10 days before the interview. Right? And in the process, particularly in the case of magistrates, we found that there were a large number of cash deposits in their accounts which they could not explain. And various people were not coming forward because the perception when we started and before. The reason why we were appointed was because of the perception that the judiciary was corrupt. But in actual practice, very few people came to us alleging actual bribery. There were other issues. There were issues of temperament. There were issues of favoritism. There were issues of bias. But very, very few came along to say that a particular judge had been paid or a particular magistrate had been proved, and with concrete evidence. After all, we had to apply rules of natural justice. We could not just, on a general perception that there was corruption in the judiciary, find judges or magistrates unsuitable purely on their general perception. In each particular case, the case had to be proved, not beyond reasonable doubt, as is required in a criminal case, but at least to our satisfaction. And I must say that what we looked at, as far as corruption itself was concerned, was only a tip of the iceberg. So when we now talk of the rot, or whatever you're talking about as far as the judiciary is concerned, keep in mind one, that we were only vetting half the judiciary, perhaps even less than half, because we were only looking at those judges and magistrates who were in office on the 27th of August 2010. Those judges and magistrates appointed after they were interviewed by the JSC, but they were not within our mandate. And when we talk of corruption today, from the evidence we have or from the reports that we get, it's not so much those that we already vetted and found suitable. That corruption that the Chief Justice is now alluding to is mostly among those who came in after the 27th of August 2010. And even as far as that is concerned, what had happened, that in a ruling that the Supreme Court gave, with which we were rather disappointed, the Supreme Court in fact reduced our mandate. They restricted us to the date of appointment, to to the 27th of August 2010.
And not before.
And not before and not after. With the result that at least 13 of those that we have found unsuitable, we had to reverse those particular decisions and refer it to the Judicial Service Commission. To this date, they have not, the Judicial Service Commission, obviously they are occupied with other matters, have not been able to hear it. But if we were allowed to go on the way we were doing, then we would have brought the vetting process to a finality insofar as those people who were there in the office on the 27th of August 2010 were concerned.
What you are saying to me, what I understand you to say is that the vetting was not proper, not complete, because we have those limitations.
No, there were two things. One is that we were only vetting those who were in office on that day,
yes,
the 27th of August 2010. And certain cases we could not look beyond the 27th of August 2010. So we had this, in fact I had mentioned this to the Supreme Court, that we would have this curious position where a person, suppose his conduct, the complaint against him was that he was an alcoholic, that he would come to court drunk, all right? And that officer could come to us and say what is complained about is after the 27th of August 2010. Today I do accept that I am alcoholic. I do accept that I go to court sometimes under the influence of drink. I do accept that sometimes I don't turn up or I turn up late, but that's not within your jurisdiction. And then we are left in that position that we have to find him suitable because the pre-27th of August 2010 conduct was in order. And we have had instances, practical instances of that. Same can apply to bribery. You could have a judge or a magistrate coming to us and say, before 27th of August 2010, I didn't accept any money from anybody. After 27th August 2010, things became difficult. I started getting money, supplementary income from these other sources. But sorry, that's not within your mandate.
What are you suggesting? That we should do a fresh vetting again if we want to salvage the reputation of the judiciary? Should we therefore set up another vetting board with expanded mandate and vet everybody?
Unfortunately, you can't.
Why?
Because as far as the judges are concerned, the judges have what they call the independence of the judiciary,
yes,
and they have these fixed tenures, permanency of tenure. The reason why we were able to vet them was because of the constitutional provision, because of the specific constitutional provision in a new constitution, which we set up this body as a transitional measure. So we cannot now subject those who have been appointed since to a new vetting process. But we had a meeting just about 10 days ago in Naivasha where we had stakeholders and we discussed this issue. And they have suggested, and we agree entirely with it, that if we were to set up, if Parliament were to consider and the JSC were to consider setting up what we call an independent complaints commission. That independent complaints commission, first of all, would be independent of the JSC.
Yeah.
Because when the matters now go to the JSC, you can say the JSC is not independent because there are judges and magistrates sitting there. And even if you have one... And lawyers. So if you have even one judge, one magistrate or one lawyer supporting a particular candidate before them, then you cannot have an independent decision. But if those matters were referred to an independent commission, what would then happen is this, that we would also open up as far as those who we have already vetted. Because if there was a complaint against someone who we have already vetted, so those before the 27th of August, that particular body can look at that. So they still remain in focus. They can't say, oh, I was vetted by the Rao team and I'm clean. You may have been clean then, are you still clean? So if there is a complaint, this independent commission can look at it. Similarly, all those who are not subject to the mandate of the vetting board also come into that particular under that particular complaints commission, right? So that we now have a body which looks at those who were before 27th August and those who are there after. So in a way, it's a vetting process. Because after all, what does the vetting process depend on? It depends on complaints from the public. So if those complaints were referred to this independent body, they could look at them. Of course, our mandate went further. We looked at other issues like temperament, we looked at fairness, we looked at the way their writing skills, their oral skills, etc., which may or may not feature in a complaint commission. But if they do, they certainly can look at that.
Why would the Ombudsman not be that independent complaints commission? Why is it inadequate to do that?
You see, keep in mind that we set this board up, the structure that we built up very laboriously, and it is a very competent structure today. We have all the facilities. We have our hearing rooms, we have our researchers, we have our investigators, we have our people who record it, and so that we have a complete setup there. To dismantle that setup, a wheel that we invented, and you then start reinventing the wheel, would not be proper. So we are urging Parliament and JSC to consider, retain, not us, retain the structure, because this would be useful to you.
I'm asking, the Ombudsman as it is today, can it take over from you? Does it have the structure?
They don't have that structure. The structure that we have built up is unique. It doesn't exist in Kenya. He can use it. JSC can use it. The government could use it, because even the president is talking about vetting in a way, as far as the lifestyle is concerned, as far as forensic audit is concerned. All that can be done under this particular umbrella, because it's there, it exists. And I'm saying don't dismantle it and then start again.
I've seen articles in newspapers written by lawyers, Maina Kiai, Wachira Maina, arguing that even your vetting itself, the way you did it, was not foolproof. And they give an example of the Justice Noi, who is now in problems. They say he was involved in other matters before, involving some judgment he changed, involving...
I think matters in plural is perhaps taking it too far.
Yes.
One matter you can say, and as you have referred to.
Yes.
But it would be unfair to discuss Justice Tunoi.
Yes.
After all, he is been referred to the President, for the President to set up a tribunal. The allegations against him have to be looked at. And until they are looked at, and if the tribunal comes to the conclusion that he is guilty of the allegations which have been made against him, we have to, in all fairness, and applying the rules of natural justice, I think we have to give him that opportunity to defend himself. So in the eyes of the law, in the eyes of the Constitution, he is innocent until proved guilty.
But the argument is about things they did before. You vetted him.
Maybe. But the thing is that when he is facing a tribunal, where he is facing such allegations, it would not be proper, and that too but for the chairman of the vetting board to be discussing Justice Tunoi when he is already facing a tribunal.
But since your end is your term is ending at the end of March.
Yes, you see, our term technically finished at the end of December.
Yes.
And the Parliament gave us that window that those matters which we had started before the 31st of December but could not conclude could go on till the 31st of March. Right? And then there is another period of at least 30 days for us to wind up, to prepare our recommendations, etc. Whether that 1 month is enough or not is a different issue. But for the moment, we have until the 31st of March, plus 1 more month, which takes it to the 30th of April.
Are there some people waiting to be vetted?
As far as vetting is concerned, the only one person who is still to be vetted is Justice Umbija. You may recall that we had found Justice Umbija unsuitable. Then we set aside that decision of unsuitability on revision because he alleged bias. And even though we said that there was no actual bias, just the allegation of apparent bias we said in all fairness we would set aside that particular finding of unsuitability and ask him to be vetted afresh. Now when we did that, we couldn't do it immediately at the time because there were certain time constraints which had been imposed by the Act. The judges and principal magistrates, chief magistrates, etc. had to be vetted according to that legislation by the 28th of March 2013. That was because the Parliament intended that those judges and magistrates should be free to hear any election petitions. We were not able to complete the vetting of all judges and all principal magistrates or chief magistrates by that date. And so we asked Parliament to remove that time constraint, which they did, but it took time. Immediately that constraint was removed, we started vetting all those who fell in that particular category, including Justice Umbija. But Justice Umbija objected to it. He called it re-vetting. We said it's not a re-vet, it is a fresh vetting, because the proceedings before that were a nullity. So he went to the High Court. The High Court said, upholding the Supreme Court decision, that the High Court had no jurisdiction to look into it. It was a matter, it was a process entirely within the scope and mandate of the vetting board and could not be looked at by the High Court. So that was the ruling. He went on from there to the Court of Appeal. Court of Appeal overruled the High Court and substituted a decision of suitability. Now we have a big problem with that particular finding of suitability, because it is neither for the High Court nor for the Court of Appeal to actually declare a person suitable. That is the sole mandate under the Constitution of the vetting board. The judge has to come to us whether we find him suitable or whether we find him unsuitable. And if by 31st of March we are not able to do that, then he will not have been found suitable or unsuitable, and he will remain in limbo. That matter is therefore now before the Court of Appeal, before the Supreme Court, because we could not allow that decision of the Court of Appeal uncontested. So we have challenged it. We are in the Supreme Court, and the matter is likely, it will be fixed for hearing on the 25th of February of this month. And hopefully I hope it proceeds, and hopefully I hope that we get a decision well before the 31st of March. Either way, we have no particular interest in Justice Umbija, whether he is found suitable or unsuitable. Right? But the decision must come from us. He must be interviewed by us. That's all we say to the Supreme Court.
And if it does, we say you remain in limbo?
Otherwise he remains in limbo. Then he can't sit. After 31st of March, if this matter is not heard and is not vetted by us again, then he cannot sit as a judge.
What if the Supreme Court decides he can sit?
The Supreme Court can dismiss our appeal.
Yes.
If our appeal is dismissed, then as far as we are concerned, we would simply write to the GSC saying this is the position as far as Justice Umbija is concerned. We ourselves did not vet him. Now it's up to you how you want to treat the matter. All right? So apart from Justice Umbija, the only matters that we have now before us are certain reviews of those magistrates. All judges' matters have been reviewed. Only the magistrates, some of the magistrates that we found unsuitable, they are before us for review. A number of reviews we have already heard. The rulings are pending. There are a few, I think they will be heard this week, and I think we will be done as far as that's concerned, apart from then writing our, deciding and then announcing our determinations.
Why is it necessary to have reviews? Once you vet somebody and you make a decision, why do you have to do a review?
You remember that this...
And they are the same people.
No, it goes to a different panel.
Oh, it's a different panel.
Yeah, it's not the same panel that actually heard. It used to be, but then Parliament changed it, and rightfully so. It goes to a new panel, and the new panel hears it and makes a recommendation. All right? So what happens is that you must realize that we are the first and the last word. And anyone who has been found unsuitable, he will look for avenues to show that determination of unsuitability should be revised, because some new evidence has come to light which was not available, or that the panel which heard it made a mistake which is apparent on the face of the record. If they satisfy us on those two grounds, then we look at that review favorably. And although it is very technically, it is only limited to those two, realizing that we are the first and the last word as far as the review is concerned, and realizing that we are dealing with the life and career of a person who has been in the judiciary for maybe 10, 15, 20, sometimes 30 years, we are extremely careful. And if at all we feel that that panel had been unfair and the verdict or the decision could have been otherwise, then we allow that little flexibility beyond simply the new evidence and a blatant error on the face of the record. And a number of those reviews have been allowed. But then we are the first and the last word, and I think we must give them that opportunity.
I'm not casting aspersions on your board, but we have seen what has happened with the police vetting. We have had complaints, threats to the police service commissioners who are doing the vetting of the police. We have had issues about corruption. How immune or how targeted is your board as compared to the police?
Let me say this, that I am satisfied. There may be decisions, one or two, with which even I may not agree, but it's a board decision. We decide the matters at a board level, 9 of us voting. And you may find, if one starts looking at the record, that in certain matters I may not have agreed with the majority, but we go with the majority decision. The almost a good majority of those decisions are unanimous, but some are on a split vote, all right? So that we may or may not agree on all of those who have been found suitable, or all of those who are found unsuitable, all right? To that extent, as you say, there may be members of the public looking at a particular judge or a particular magistrate and say we don't agree with that particular decision. But then you cannot please everyone. You have to go through the process. The process has been very fair. We have treated them with dignity. We have given every opportunity to those people to come forward with all their whatever defense they have. They have been represented by lawyers, very competent lawyers, so they have been given a very, very good hearing. So on the whole, I think the process has been, as I said, on the whole, successful. It may not have been to 100%. No system is 100% foolproof. So I don't say that our system was foolproof. But what is also very commendable, and I think I said it, and perhaps you saw it in the newspaper yesterday, which carried a profile of mine in the nation, that this process has been totally immune from interference. We have had no interference at all. We were set up during the time of President Moy, with Raila Odinga as the Prime Minister. During that period, we hadn't the slightest approach from anyone in authority to influence our decision one way or another. After President Uhuru became President, we have never had the same either. So that this process has not had any outside influences, and I have had no complaints about the integrity of any of our members. Personally, I am satisfied.
If there was a question of integrity, would you know? And would it would it be effective anyway? If it was brought to our attention or even my attention, I would not just sit back on it. I would have it investigated. And if it affected a particular judge or magistrate, we would see to it that that particular matter... Has it happened? Have you ever had any complaint or allegations or... No. We have had absolutely no allegations from outside of any interference or any person having been compromised, and that speaks a lot. Unlike what you have been hearing in what you call the police vetting. What about lobbying?
Whether they have been lobbied, but as I said, the decision is taken at the level of 9 board members. Like in the Supreme Court, they say that when you have 7 people sitting on an appeal, either you go to influence, or you go to bribe, or you go to whatever, all 7, not just 1. And same thing applies as far as the board of the vetting board is concerned. We are 9 people.
You said you are 9 people, and you said there are different panels of the 9.
There are different panels, but that panel only makes a recommendation. It makes a recommendation to the entire board and the entire board then goes through it. We've been given the full copies of the record of what took place before another panel. What is the recommendation of this particular panel now, before they actually vote on it, as to whether to accept the panel decision or not to accept the panel decision. And we have had cases where a panel decision has not been accepted, where the majority say, no, we are not happy with that. Not for issues of integrity or something, but we disagree with this particular recommendation and we vote otherwise. And it happens.
What do you think? You have raised the issue about the presence of judges and magistrates and lawyer to the Judicial Service Commission, because they looks like now the question of the panel that is supposed to be set by the president. It cannot. None of those can be members of this, because
no.
of the question of.
Absolutely, it has to be an independent panel.
Yes.
Appointed under, I think it's Article 168, and I think Article 168 also lays down the composition in the sense as to who qualifies that the president would take into consideration when appointing that panel. So I think there are at least 4 people, either judges or people with qualifications where there could have been a judge.
My question is the composition of the Judicial Service Commission as it is now.
Yes.
Where we have judges and magistrates, and also they are appointing people. They do appoint judges and vet them.
True.
Isn't it a kind of tricky? Because I don't know why they decided to do that.
No, as far as the tribunal is concerned.
Not the tribunal. Now I'm talking about the Judicial Service Commission as it is now.
Yeah.
When it comes to disciplining isn't magistrates, and they are part of them. It is a compromising situation.
One can see a conflict of interest.
A conflict, exactly.
You could have a judge, you could have a magistrate, you could have a lawyer who has a particular liking or dislike for a particular judge or magistrate against whom the complaint has been received, and he can influence to some extent.
You probably appear there and then appear with the same judge.
No, that is why the proposal that the stakeholders made, and we are now making,
yes,
is to appoint an independent complaints commission. An independent complaints commission in whom the public has trust and confidence. Not the JC, because the JC is composed of, as you say, judges, lawyers and magistrates who may have an interest in a particular matter. So
they definitely have an interest.
Yeah, so appoint an independent body which looks at all disciplinary matters and then makes a recommendation, whether it's to the JC or to Parliament or whoever. And in the case of the removal of a judge, of course that power is vested in the JC alone under Article 168. It's so you can make a recommendation, but it would be up to the JC then whether to recommend to the President to set up a tribunal. Right? So you cannot give that function to that independent body. But short of that, that independent body can hear any other complaint. And it has the advantage, as I said, that it would bring within focus those we have vetted and those we haven't vetted.
What is the possibility of that recommendation being effected? You have said you have stakeholders meeting.
Yes.
I don't know who are the stakeholders and what kind of influence they have.
The stakeholders are the Law Society, the AG's office, then we have the human rights. So all the bodies which are actually stakeholders within the terms of the Act. The Act itself defines who the stakeholders are. You see? And they were all present, and a majority of them decided in favor of this particular setting up of this. So it is being recommended. Whether Parliament accepts, whether the JSC accepts, whether the AG accepts, that's a different matter. All right? But within the judiciary itself, I would think that there are members there. You see, I mean, the Chief Justice is now very concerned about corruption, as he says, has crept in again within the judiciary. And he cannot fight that battle alone. But there are within the judiciary people that he should actually bring in to discuss this problem and to say how to resolve it. You have people like the President of the Court of Appeal, Paul Kariuki. a man of the highest integrity. We have the Attorney General, a person of very high integrity. There would be others within the judiciary and outside of the judiciary, people of very high integrity. Get them together and say, this is my problem. How do we resolve this? Because it's got to be resolved. And I think before he vacates office in June, he would leave a legacy if he were able to do that.
Somebody is asking a question here. In case a judge or magistrate is found innocent after vetting, is he or she supposed to be compensated, or she or he supposed to resume work? I don't know what that means, because when you are being vetted, you are not suspended.
They don't need to be compensated,
yeah.
Because at no time before a final determination, and that too after a review, is the judge or magistrate actually removed from office. Although the law says that the moment we announce our determination that a judge is unsuitable or a magistrate is unsuitable, he is deemed to have been removed. But in practice, it doesn't happen. They wait at least until the review is heard and until the decision of the review has been announced. All right? So there is no question of compensation because they are in service right until that moment.
Maybe, I don't know whether you can remember figures or averages in terms of magistrates and judges. How many have been vetted? How many have been thrown out, and how many have been retained?
I think out of about 53 judges, 13 were found unsuitable.
Okay.
From the magistrates, about 315 of them, 25% of them. I think the average is about 25% who have actually been found unsuitable. It could have been higher if we are amended was, as I said before, and after the 27th of August 2010, and also if the public had come forward with actual evidence as far as corruption was concerned. It wasn't forthcoming. We, on our part, not only did we advertise in the newspapers, we actually went what we call on a sensitization process right through the counties. Even the prisons, we went and we talked to them. Prisons are the clients who have actually gone through the process, and they know which magistrate was fair, who wasn't fair, where there is corruption, who was approached, who approached them for, to render a particular decision in their favor or against. So we have been all over. But despite that, not all of them came forward. People say things, but people are afraid to come forward and say it.
The reputation of the judiciary is at stake, and I think that independent tribunal will be very useful. The people who come here, they show, the lawyers, the judges, they say there is rampant corruption in the judiciary.
Well, the Chief Justice says it.
The Chief Justice is.
Yes. And that's a bad image, because I think we have to slay, as they say, this dragon of corruption. If you do not have a judiciary in which people have confidence, we can resort to what happened in post-2007, post-2008, when disputes get settled on the street. It is very, very important, and particularly with 2017, when we are going to have now elections again, I think it is important that that confidence is restored in the judiciary. And at the moment, it is seriously dented.
The Chief Justice talks about, and the President, about a lifestyle audit.
Yes.
To be done by who and how? Because it looks like another vetting.
This is where they have got to act fast. And as you say, who will do it? Is it the anti-corruption? Is it some other body? Is this an independent body set up to do it? Because also remember, there are constitutional issues. The judges, as I said, have independence of the judiciary. They have a certain tenure, which is fixed. To interfere, can an anti-corruption body just ask anyone without any basis, say, produce to us your bank statements, produce to us all your assets? There has to be a basis for that, for an anti-corruption or any other body to act. But come to think of it, every state officer, including all judicial officers, including us, we all have to file wealth declarations. And those wealth declarations speak a lot. They tell you what your wealth is in terms of what shares you have, what properties you have, how many cars you have, all that. What happens, I think, in practice is that we submit them and they're filed away. They should be looked at. They should be looked at, and then if you find in a wealth declaration that the wealth shows wealth out of proportion to the legitimate or known income of the particular officer, then you are entitled to ask him to explain how and why. I think it doesn't happen in practice.
Why doesn't it happen? You can't.
Well, I think no. What is happening is that, as I said, they probably are filed away. The law requires that you file a wealth declaration every 2 years or so. You file it, and it goes into the record.
But if you,
I would say, look at them, investigate them. Have a team which actually looks at every wealth declaration and say, how did you have a property? How do you have a property which is 300 million? Where your total income in the last 10 years could not have exceeded 20 or 25 million or 50 million. How is it that you had a property of 300 million? How is it that you have 100 million or 50 million or whatever in your bank account? Explain it. When we were looking at, as I said, those officers who came before us, in each case we looked at their wealth declaration, and they spoke a lot. We looked at their bank statements over the last 3 years. They spoke a lot. Not so much in the case of judges, but particularly in the case of magistrates. That was the evidence that we had in the absence of people coming forward to complain, where those magistrates were not able to explain those particular deposits, that we put in a verdict of unsuitability.
So, like how many did you throw out because of corruption, because of that excessive amounts of wealth?
Well, as I said, at least 13. We reversed. So if you ask me, at least I have one figure of 13 which we reversed. How many others were actually victims of that particular process is difficult for me to say.
And you reversed because of what? When did you reverse it?
It was the Supreme Court which asked us, restricted our mandate, as I said earlier, only from the 4th of August to the 27th of August. So those where we had gone either before and after, as far as the Supreme Court is concerned, it was outside our mandate. So we had to look at those and say, sorry, this has to be reversed because we took into consideration a matter which influenced that particular determination, and it was outside our mandate.
But if you look at the police vetting, you find a lot of policemen with enormous amounts of money, bank accounts full of money, and they normally would not. Some of them even refuse to give the accounts. When you say wealth declaration, it's used to declare. Is there any way of yourselves getting that information without the officers giving you the information?
No. Once you have your wealth declaration,
you can cheat.
Once you, of course, you can cheat.
Well, can you find independently how much I owe?
But this is
how much I own.
I think it's possible. Yes. If you have doubts about that particular wealth declaration, if you have doubt about that particular bank statement, then you can ask for clarification. You can have it investigated, and you ought to do that. And we have done it. Yes. It's a very important source of information.
So you have got 1 month to write a report.
Yes.
And where does the report go to? And how is it useful?
The report?
When you finish vetting people and you finish that 1st of March, you got 1 month to wind up and write a report. What happens to the report?
You see, this process has been unique not only for Kenya, it's unique in the Commonwealth, it is in fact unique in the world. There hasn't been a similar process anywhere. So what we have done is an example not only for Kenya, it's an example for countries outside Kenya to look at. 1. 2, through our experience of having gone through 55 judges and 300 magistrates, we have seen the weaknesses of the system, whether it is about the transfer of judges, it's about the amount of work they do, it's the delays in judgments, it is whether it's the judicial officers at the level of judicial staff, and that's again a big source of corruption. They have to be looked at. So it's not enough just to look at judges and magistrates. A lot of corruption takes place at the level of the judicial staff.
You can see even the former judicial in court.
That's right.
And of course chair staff.
Yes. Soleil was, again, it's like in the case of Justice Tenoy, something we can't discuss because it's before the court. But she was a very competent officer, and she brought in a lot of changes in the judiciary. And I think perhaps what happened is that because she was competent and because she brought up so many, too much reliance was placed upon her. All right? Because whether she was involved or whether she wasn't involved, I think there has been expenditure on the part of the judiciary, which I think is something which we need to look at and say, how come you buy a house of 300 million in an area like Runda? You can buy 2 houses at that price in Mathaiga, which is a higher elite residential area. How do you spend 100 million on refurbishing that particular property which you bought for 300 million? You actually get a block built for the Court of Appeal without proper investigation, and that is not being used today. How much money has been wasted? The donor countries, in all their honesty, in all their enthusiasm to reform the judiciary, have contributed so much money to the judiciary. And then if you find that the money has been wasted on expenditure which should not have been made, I think then it sort of renders a very poor picture.
The Public Accounts Committee was seized of the matter, and they just upon the parliamentary report to Parliament is going to be debated, and certain magistrates who are in fact in the judicial, a magistrate and a judge in the Judicial Service Commission, which oversaw those things.
Yes.
And they're still there. Nothing has happened with them. It looks like the PSC is not very useful. I
think this is what happens in Kenya. We talk, we complain, and then no action is taken afterwards. I think all these things now, the concerns about corruption, not only in the judiciary, but in the public sector, I think we have to do something very positive. Even if it's for the President to bring in a few people to sit down and say, how can we tackle this problem that we have in the judiciary, in the executive, in the tender boards, and all over. Because this is a vice which must be contained. Right? On the roads, when you drive out, when a policeman stops you, you immediately realize that he's not there to enforce the law.
No, of course not.
Because he's trying to extract money from you. So he's looking around to find, is there a way that I can nab you? All right? It doesn't happen in any other country. I mean, I have lived in Holland for 12 years. You see a policeman in London. You feel so comfortable. You think that here is a person who is going to look after you. Here we just fear someone. The moment we are waved down, we say, now what's happened? All right?
In fact, I'm wondering whether, when you're doing your vetting, just like the police are doing vetting even now, the officers you are vetting, or the officers being vetted by the police officers, do they, in their background when they're working, or a magistrate, do they fear that there will be consequences of whatever they do, that there is somebody looking?
If they now have, like as I say, if you have a complaints commission, as far as the judiciary is concerned, then those judges and magistrates will know that someone is looking. And if their complaint goes to this particular body, they would be interviewed and they would be asked questions. Before that, it was like immunity. I was, as you know, I was in the office of the Attorney General from 1970 to 84. 84, I went to The Hague. I stayed there for 12 years. From it, I came back in 96. I haven't seen a single case of corruption prosecuted, or at least prosecuted successfully. Every person charged goes to court to stop it. It was unheard of in my time. If you were innocent, if the charge against you was not justified, you went and fought it out before that particular magistrate. You don't go to the High Court to have it stopped. Invariably, no prosecution here starts.
No.
None gets concluded. Because if you have to have a deterrent, you must have, at least now, even if it means having those persons in the dock is a deterrent. Of course, to have, if they were...
But I've seen today's papers, the Ethics and Anti-Corruption Commission saying they're prosecuting so and so, 200 people, of the people given by the President to Parliament. They are not saying we have prosecuted and jailed, and even the money they say they have recovered is peanuts.
No.
So
So
where is the future?
Having taken to court doesn't solve the problem.
No.
You see, people should be afraid. There has been corruption here right from 1963 when we became independent. There has been corruption, but it was not open corruption. Then we came to a stage where it's open. Everyone demanded, and they said, if you want this proposal through, you must pay me 20 million. You want that one through, you pay me 10 million. And once you pay him 20 and you pay the other fellow 10, everyone up the stream wants to be paid.
But you see, to me it's very frustrating, because why go public places every night? And this is throughout this country. Policemen go to bars, every bar from one to the other, in vehicles, in police vehicles.
Yes.
They extract 100 shillings, 200 shillings per trip every night. And then we say policemen have, and that money doesn't end up with those policemen in the vehicles. It goes all the way to somewhere.
Yes.
Obviously. So why would I have any hope at all in the police vetting? And it happens, and it will happen tonight as we speak. Why should I have any?
That's true. I think, that's why I say that I think we need to get together, people in positions who can help and find out what can be done. Not that much can be done, but at least whatever can be done has to be done. Otherwise, we'll just keep on talking. We'll say there is corruption, we must stop it, there is zero tolerance as far as we are concerned, and the matters just go on.
But do you think there is political will from the top to finish corruption in this country?
Well, the president has been saying so. I think every occasion he stands up, he says so. And at least he's aware that there is corruption. And as I say, concrete measures have to be taken. You have to put action to those words. Right? Same as I say with the Chief Justice. Chief Justice alone can't fight it. President alone can't fight it. You see, but then you've got to devise that mechanism to see how we can fight it. And even if we can't fight it altogether, even if we can fight it to a certain degree, I think we will have achieved something.
Thank you very much, Mr. Rao.
Thank you.
It was nice to talk to you again.
Thank you.
And now, from now, let's go to this Christian group that's going to sing for us.
Okay.